the first place. So it was founded in 1920. We're a nonprofit. We have state affiliates in every state, and we do what we can to safeguard people's civil rights. So click through, please. What does that look like? It's kind of what you may have read about in the news. We do litigation. We lobby in the legislature and city and county councils. We organize, and we also do public education and press work. So that in a nutshell is our organization. I'm sure many of you are familiar. So let's move on. As far as the agenda for today, we kind of split it up into a couple sub areas. Emily is going to provide just an overview of the First Amendment, the numerous rights that it protects. Then we're going to look at the context of in-person activities, right? What rights do you have when you speak in public, attend protests, et cetera, et cetera. Then we'll also think about written activities. And then finally, First Amendment rights in the law enforcement operation context. We know that this has been a more pressing issue in light of recent enforcement actions that have occurred on Maui and Hawaii Island. So we wanted to address those rights as well. And of course, we'll leave time for Q&A at the end. So one clarifying point is that even though we're separating in-person activities from written activities, formally speaking, legally speaking, there's no sort of distinction as far as your First Amendment rights, but we think from a practical perspective, it helps to sort of divide up those two areas. So with that, I'll pass it back to Emily.
Thanks, Wookie. So because we're all lawyers, I have to give this disclaimer up front, right? This is an informational presentation. We're not giving out legal advice. If you are arrested or in a removal proceedings, if you're asked questions by someone who, I guess, needs legal advice, they should always be consulting with a lawyer. This isn't a substitute for that. And then we also add the caveat that in this current administration, policies and practices are changing very quickly. Aaron in particular is going to be talking about some of the things that are happening legally right now that will be different probably a couple weeks from now. It could be different tomorrow. So just keep in mind that we're talking about what's happening in the present moment, but that is changing rapidly. So to jump right in, First Amendment is a part of our Constitution. We have the Bill of Rights that establishes fundamental rights that apply to everybody located in the United States. So we're including immigrants on this, and we're going to talk about some of the caveats of that. We also, I should add, also have similar rights under the Hawaii Constitution, but since immigration is a federal area of law, we're mostly going to be talking about the federal rights. Today, we're going to be focusing on this kind of second half of the First Amendment, and this gets broken down into a couple of larger topic areas. So free speech, free press, the right to protest, the right to assemble, we also call this association, and the right to petition. So jumping right in, as Wookie said, we kind of broke this down into in-person and written activities, not because there's a legal distinction, but because we think it might be easier to conceptualize, especially if you're trying to navigate your own personal activities or help someone else navigate this area. So First Amendment in person, we're going to talk about speech, assembly, and protest. So we all have freedom of speech. That means the government can't tell you what to say or what not to say. It also means you can't be punished. There's no retaliation for what you do say. And I have this little asterisk that there are some exceptions we're going to talk about. But overall, this includes political ideas, and it definitely includes criticism. I think we can fairly say that the right to criticize the government is sort of the fundamental heart of freedom of speech in the First Amendment. It is important to note that the government can regulate when and where you say things. So for example, requiring permits for protesting, these are called time, place, manner restrictions, but especially when we're talking about content, that's the rules get a lot stricter there. So it's almost easier to talk about what are the exceptions to freedom of speech. So there's kind of four main categories. We call it incitement, which is statements that are intended to lead to the commission of a crime. And it's important to note that this is like kind of specific intent. It's not just saying things like, I support undocumented immigrants, right? That's not incitement. It's specifically intended to lead to the commission of a crime. There's also defamation or libel. I included the picture of Taylor Swift because she had a big defamation case. But these are false statements that harm somebody's reputation. There's obscenity, which is an appeal to the prurient interest, basically anything sex related, although there's room for interpretation there. And then true threats of violence. And this is, there's a lot of case law around what counts as a true threat, but it's a serious statement that the speaker intends to commit violence, and usually that they intend to commit violence, soon. So these rights, the right to free speech, it does apply to non-citizens. We have this case from 1945. As Wookie had said, there was a lot of fear in this country around kind of radical immigrants. And actually some of the foundational case law, I'm going to talk about this case and then another one a little bit later, are coming from that era where actually there was a lot of fear about communism. And so, the US Supreme Court said freedom of speech and of press is accorded to non-citizens residing in this country. Now, I have this caveat because Bridges did not specifically address all types of immigrants. It especially didn't talk about undocumented immigrants. And there has been some debate in the case law about how far freedom of speech extends in terms of different immigration statuses. So we here at the ACLU, we strongly believe that the same rights should extend to everybody. But we wanted to add this caveat that we can't be absolutely certain until we have something in writing from the US Supreme Court. The second right to talk about is freedom of assembly. We also call this freedom of association. And really what this means is the right to gather peacefully, to express, promote, pursue, and defend shared ideas. And this could be in a large public gathering like a protest. It could also be through association with other people with similar interests, such as being a membership of a particular group, being even, I don't know, a member in a Facebook group or a student organization. And so I guess kind of the key line here is that the government can't tell you who you can or cannot associate with and can't punish you for who you associate with in terms of retaliation. Again, some caveats I'm going to discuss on the next slide. And again, the government can regulate when and where you say things like protest permits. These are also called time, place, and manner restrictions, right? But the idea is you have the right to assemble, you have the right to associate with people, and the government can't punish you for expressing that right. So the exception would be, say, illegal acts. These can take place during an assembly, right? So things like rioting, blocking traffic, anything that's illegal in its own right wouldn't necessarily be protected. And then conspiracy to commit a crime. So if people were to gather and plan out a crime and start taking steps towards that crime, that wouldn't necessarily be protected under the First Amendment. However, there would need to be specific intent to commit the crime, meaning everybody's gathering. I mean, think like Ocean's 11, right? Everybody's gathering, they're planning their heist. Everybody has the same specific intent to do something criminal. And so we caution this idea of kind of guilt by association. It's something that the ACLU has seen get used in the past. It shouldn't be used, but it is something to be aware of just because it can get used by the administration or by the federal government to punish people who are associating with people who do commit crimes. So something to kind of keep in the back of your mind. What is not an exception are unpopular ideas. And I have this picture of a protest. This is from a case that the ACLU was involved in Skokie, Illinois, where we were securing the rights for Nazis to have a demonstration because this right to assemble, this right to protest, it exists for everybody and it's not about ideas. So that ought to apply even to non-citizens, right? I say that ought to apply because the other case that I need to talk about, this is from 1952. It's kind of, we're getting into like the heart of the McCarthy era. And the US Supreme Court authorized the deportation of people who had been members of the Communist Party. And there was a statute that said anybody who had been a member of the Communist Party could be deported, and the Supreme Court upheld that. So while we again believe that this right should apply to everybody, there is sort of this asterisk. I think there is, let's see, a question whether this case is still valid case law. There's, I think, good reasons why it shouldn't be valid anymore, or why it should have a very narrow application. In this case, they had found that the Communist Party, like there were factual findings that they were attempting the overthrow of the US government. If the case is cabined to those facts, it's not going to apply to all that many people, especially when we're talking about people involved in like pro-Palestine activities. So again, asterisk, but we think this right to assembly should apply to everybody, including non-citizens. And so now we get to the right to protest. So protesting is protected because it's both speech and kind of public assembly. That doesn't mean that the government won't punish people anyways. And so we wanted to offer some tips. And Liza, I'm so glad that you linked to the National Immigration Law Center earlier. I think they have wonderful resources. I included a link here because they go into some more detail for ways for people to be safe while protesting. I think our first tip is to create a safety plan. And this would include like making sure that you have contact information for an attorney, like printed out on your person, to plan if you have children, to plan for childcare if something were to happen, to your other constitutional rights, especially Fourth and Fifth Amendment rights. And Wookie's going to talk about those at the end. Be familiar with emergency exit routes in case something were to go south. Leave mobile devices at home. Consider turning off biometrics to make it more difficult for police to search your mobile devices. And then consider avoiding posting too much information on social media. And Aaron's going to talk about that a little bit as well during his section. So we are getting a lot of questions about kind of who is most at risk in terms of immigration enforcement in these rights. I'm like making a huge guess here, but I sort of wanted to give you all a rubric for how to think about these different issues. And especially as Aaron's going to talk about some of the laws that are being applied here, or that we're seeing the government use right now. So I think the group that's most at risk is anybody who is undocumented, because they don't have a legal hook to be in this country legally. So I think that's the biggest category at risk. The next category is visa holders. And that's sort of what we're seeing in terms of revocations of F1 student visas. This is a bigger category of risk because revocation of visas is more discretionary. And then I would say conditional green card. I included COFA in this category as less at risk, but I think we all know the cases where people who have green cards are still kind of being picked up and subject to deportation proceedings. More safe would be someone who is recently naturalized. And we're making this distinction between recently naturalized and naturalized just because we're guessing that someone who is recently naturalized would be more at risk of, say, the government kind of reopening their naturalization application and sort of scrutinizing the information in it. And then I think most safe, but we're still not going to say 100%, is someone who is a birthright citizen. So at that, I'm going to turn it over to Aaron to talk about First Amendment in writing.
All right, thanks, Emily. So yeah, I'm going to be talking about the First Amendment in the context of written speech. And as Wookie mentioned earlier, all of the general rules for the First Amendment that we've already discussed also apply to written speech. There isn't really a different standard, although the Supreme Court has emphasized that the amendment specifically protects the freedom of press. It also protects the right to petition the government for redress, which generally means any request for relief or assistance from the government, for example, lawsuits or police reports. Next slide, please. So yeah, as we discussed, the First Amendment prohibits restrictions on speech by the government, but as Emily also mentioned earlier, it also excuse me, prohibits retaliation because of engaging in protected speech. So if you engage in one of the types of speech that we've been discussing and the government takes some adverse action against you, which may include arrest and detention in the immigration context, you may have a defense if it's a criminal prosecution, a civil claim for retaliation, or as mentioned, defense to an adverse immigration action. And that's one of the theories that attorneys, including the ACLU, are using right now to challenge, especially the arrests of students who seem to have been arrested only for engaging in speech, especially pro-Palestinian speech. Next slide. So I'm going to talk about one case that's ongoing, which many of you may have heard of, about a graduate student at Tufts University in Massachusetts named Rumeysa Öztürk. So she was arrested in March and was placed in deportation proceedings. And so far in court, in a case that ACLU is participating in, the only explanation the government has provided for her arrest and potential deportation is that she co-authored an op-ed in the Tufts student newspaper that criticized the Tufts administration's response to several student Senate resolutions concerning human rights violations in Gaza. So importantly, based on the fact that the government hasn't said otherwise so far, it appears that they only arrested her and put her in removal proceedings because of her speech on an issue of public concern. And so in that case, the ACLU and other attorneys are arguing that that is unlawful retaliation. Next slide. So one way the administration can target students specifically is by revoking their student visas, and that's what happened to Rumeysa. The government revoked her visa without giving her notice, and then once you revoke a visa, you no longer have the ability to stay in the United States, and you become deportable under the Immigration Nationality Act. Next slide. So, and then for others, including Mahmoud Khalil, who many of you have also probably heard of, the government is using a different reason in the INA for putting them into deportation proceedings, which is it's a bit legalese, but I've copied it onto the screen. If the government has reasonable grounds to believe that that person would have potentially serious adverse foreign policy consequences. So their government is not using that ground for Rumeysa, but it is using it for Mahmoud, who is, some of you may know, is an LPR. So he was not just here on a visa, he had permanent status. And so it seems like the government needed to find another reason to justify his deportation. Next slide. So continuing with Rumeysa's case, much like Mahmoud Khalil, she was after she was arrested, she was quickly transported to Vermont by ICE and then to Louisiana. In court, the government is saying that's because there wasn't sufficient bed space in ICE detention facilities in New England, although the court in Vermont noted in an order last week that the ICE facility in Maine did seem to have sufficient bed space. It seems like the government might be sending people to Louisiana for, among other reasons, to engage in judge or forum shopping because they believe that the judges there are going to be more amenable to the government's arguments. Rumeysa filed a habeas petition, which is one vehicle for challenging the constitutionality of a detention and removal on the grounds that her arrest, detention, and potential deportation are in retaliation for protected speech under the First Amendment. The judge in that case just ruled last week that the government has to transfer her back to Vermont by May 1st. It says that the government previously essentially ignored an order from the District of Massachusetts to not transfer her when they transferred her to Louisiana. And that same order also noted that, as I mentioned earlier, the government thus far hasn't provided any other reason for her removal aside from co-authoring that op-ed. And the court said that unless the government, or indicated that unless the government provides a non-speech reason for her detention and potential removal by the end of May, that he's likely to grant her habeas petition and order her to be released on the grounds that the government's action was, again, unlawful retaliation only for engaging in protected speech under the First Amendment. But Remesa's case is still sort of at the beginning, and any decision by that judge who I was just talking about, who's a United States district judge, so at the lowest level of the federal court system, that order is likely to be appealed. Next slide, please. So in terms of what this all means, as Emily mentioned earlier, we're not giving legal advice here, but just a few comments. If you're somebody who's an immigrant and you're going to be speaking out, especially on hot button issues, you might consider preemptively contacting an immigration attorney. If you're going to be speaking on social media, you might want to think about checking the privacy settings on your posts and adjusting those just to be safe. All right, and now I'm going to hand it over to Wookie to talk about the First Amendment in the context of ICE operations.
Thank you, Aaron, and of course, thank you, Emily. So I'm going to talk about how the First Amendment applies in the context of law enforcement raids and ongoing police actions. So as many of you know, about a month ago, a senior Hawaii ICE agent announced that essentially ICE will be taking certain measures to prevent the public from interfering with the operations. And what that news story quotes this official as saying is that ICE is going to establish a perimeter and then provide up to 2 warnings to individuals who enter that perimeter. And after that, they will arrest folks. So this is all extremely concerning and arguably infringes on the public's right to record law enforcement, which is critical for transparency and accountability. So I wanted to focus kind of on the basics. Why does it matter to record law enforcement in the first place? What is the state of the law? What are some practical tips for you all as advocates who are out there and who might be parties to or witnesses of different raids? What practical tips can you follow? And then what happens if during that encounter, ICE starts, harassing you or making demands of you? So next slide, please. Just at the outset, why does it even matter? Why should we even care about reporting law enforcement in the first place? The photo on the left, for those who don't remember or recognize, this is actually a photo of the group of bystanders who witnessed George Floyd's murder. And Darnella Frazier is the woman who's the third woman from the right holding up her phone. And it's her video that really changed everything as far as how we viewed what happened to George Floyd and the aftermath. In short, right, recording matters for accountability, transparency, and protecting people's rights. It promotes accountability and oversight by creating an objective record of what happened. And of course, it sometimes, not always, deters misconduct, because when an officer knows that what they're doing might get posted or live streamed on social media, they're probably more likely going to follow the rules, follow the law. And this is especially important in immigrant communities where officers might otherwise be exploiting the fear and the language barriers and the other obstacles for those communities. And then, of course, right, when you have video evidence, that can be used in legal proceedings, not just to affirmatively show that someone violated your rights, but also, for example, if you get prosecuted for interfering with law enforcement operations, if you have video showing that you didn't act aggressively, you were not standing in the way, you didn't touch anyone, then that really helps. And of course, finally, right, it supports the broader movement, and simple photographs, simple videos can galvanize entire movements for justice and social change. So it's really important. Next slide. That's the bottom line. Now, what is the state of the law? In short, it can't be really more clear here in Hawaii. You have the right to record government officials engaged in their official duties in public places. So there's a lot of case law out there. I'm putting on the screen kind of two relevant cases for us here in Hawaii. The first one involves the Ninth Circuit, which is the Federal Court of Appeals that governs Hawaii. That court clarified that this right exists under the First Amendment. And interestingly, this lawsuit, which was filed by the ACLU, was on behalf of immigration advocates. They were at the US-Mexico border at a port of entry, and they were taking photos of kind of the checkpoint. And what happened was that the CBP agents confiscated and destroyed these advocates' photos of the checkpoint. And essentially, the court ruled that in doing so, they violated the First Amendment right to record. Similarly, not in the immigration context, but in 2017, the Hawaii Supreme Court ruled that the Hawaii Constitution's First Amendment provision, which is Article 1, Section 4, that also protected the right. And in that case, there was a journalist who was filming a traffic enforcement operation, and the two officers arrested him for criminal interference, harassment, resisting arrest, etc., after he used his iPhone to film those officers. And there's other aspects of the law that protect this right, but the bottom line is it's firmly established. Now, you may have seen this legislative session and in past sessions, bills trying to codify or create statutes to protect the First Amendment right to record. Don't be fooled by the fact that those bills died. The right still exists, even if those bills did not pass. Those bills were trying to create specific protections under the Hawaii revised statutes to protect the right. But the fact that they did not pass does not mean that you don't already have the right currently. So that's a really important point to note. Next slide. Of course, as with a lot of rights, there are caveats. The right is not absolute. And so here are the three important points that you want to know about the right. First, where you are recording from matters. So the case law talks about being in a public space. And really, it's a little bit broader than that, because it also means anywhere you're authorized to be. So if you are on private property with the permission of the landowner, right, you can record. And so if you're also standing in a public place, you can record, but don't trespass onto someone's property to record. Don't sneak into the restricted area of a government building to record, et cetera, et cetera. The second caveat is that you can't interfere with law enforcement operations. Now, the meaning of interfere is incredibly vague, and law enforcement will extend the scope of that word to as broad of conduct as possible. But as the Hawaii Supreme Court lays it out, the standard is, quote, whether a reasonable officer would conclude that the individual's action is interfering or about to interfere with the officer's performance of his or her duties. So really the question is, what duty is the officer performing? And are you doing anything to interfere or potentially interfere with that duty, right? And so that's the question. Of course, law enforcement is going to claim that you're just standing there looking, observing, standing in stationary in one spot is interfering. And that's when you can hold your ground and assert your First Amendment right. But we'll talk about that in a second. The last point is that, as Emily alluded, the right is subject to reasonable restrictions as to time, place, and manner. And the important point that I want to emphasize here is that under the law, Sure, the government can impose some of these time, place, manner restrictions, but they must be narrowly tailored. And importantly, the second part of the second bullet point, leave open ample alternative channels to engage in protected activity. So what that means is, if you're trying to observe an ICE raid in progress at your community member's home, and the ICE agent says, sorry, you can't film here. I want you to go a mile down the road and film from there. That is not okay. That's not a reasonable time, place, manner restriction, because you're not actually able to engage in the activity of reporting law enforcement. So you would have the option to push back on it, but that leads to the next slide, which is the practical Emily again. So the practical tips, right? You can always push back, but here are our practical tips for if you're out in public recording an ICE raid, right? At the outset, just try and be at a safe distance from the law enforcement. Don't hide the fact that you're recording, right? Be open about what you're doing. By showing that you're openly exercising your right, you're signaling to law enforcement that you have that right and that you're not afraid to assert it. And as I mentioned, don't physically interfere with police, right? They may have the ability to order you to move around or whatnot, but you don't want to give them any reason to arrest you or threaten to arrest you with obstructing. Similarly, if they order you to do stuff, talk, act calmly, avoid escalating, and also clarify your purpose. Officer, I'm not interfering. I'm just exercising my First Amendment right to record what's happening from a safe distance. Right. And it's up to you to decide what your risk tolerance is if you think that what they're telling you to do is, unconstitutional. But to be honest, in this political atmosphere, I think it's better safe than sorry. And that's why the last point on the left side is, comply with what law enforcement says. And even if you think they're wrong, film what they're doing because someone else, whether it's an ACLU attorney or some other civil rights attorney, can assess after the fact whether what they did violated the First Amendment and consider whether to, file a lawsuit. But you don't want to risk your own personal safety and potentially get arrested, because in this climate, that is the last thing you want. Some last tips: while you're recording, try not to narrate. You want to let the video speak for itself. And don't say anything about the target of the raid that might be incriminating. Don't share the name, don't share the immigration status or criminal history of folks who are depicted in your video. Instead, focus on what law enforcement is doing, right? Because at the end of the day, the Constitution constrains government action, meaning what state and county officials are doing. And also capture relevant context, right? Pan through the scene to show the entire location. What else? Use a passcode, because as Emily or Aaron alluded, law enforcement cannot coerce you to give up your passcode. They can ask you to put your thumbprint on the phone. They can get you to, if you have Face ID, to look at the screen, right? And so the safest option in this environment is something where you have to type in text, because that's protected under the Fifth Amendment right against self-incrimination. And finally, after you have observed something and recorded, make sure you preserve the original copy of the video. Don't edit it. Create a copy of that file if you want to edit it and repost or what have you. And then relatedly, be very strategic about whether and also when to post on social media, because it could give folks a heads up. It could endanger the people that were involved. I'm not saying that you shouldn't post at all, but it's be strategic about it. Don't just post it because you want to post it. And so with that, I think that's the last slide. Is there one more slide? Oh, I'm going to breeze through this because we actually co-hosted a separate Know Your Rights about this very issue of what to do when interacting with law enforcement. But the bottom line is if, let's say, you're observing an immigration enforcement operation in progress and an ICE agent comes up to you and starts talking to you, just remember these two really important rights. You have the right to remain silent. You have the right not to be searched without, a basis to be searched. And the slide sort of lists some of those tips about exercising your rights. And we will share links to our past Know Your Rights so that you can view those as well. It goes into much more detail on this very slide. And so with that, I think next slide, we'll open it up to questions. So thank you.
Excellent. And I am going to pause the recording at this time so people can share freely.